Hello viewers, this is Dr. Tasneem Sultana, Assistant Professor in ICFAI Law School, and in today's session I will be dealing with general defenses in torts law. I have divided it into three sections. The first section will be with the definition of tort law, and in the second session it is general defenses, and lastly the conclusion. Before I begin with the defenses, let's see what do you understand by tort law. Tort law is actually the area that covers most civil suits. In general, any claim that arises in civil suits, except with the exception of contractual disputes, they all fall under the purview of tort law. To begin with, the word tort has been taken from the Latin word tortium, which means anything which is twisted, anything which is wrong. That means if someone has done you some wrong, then you can seek justice in the form of payment by taking them to the court. Now, coming to the definition of torts, many jurists have defined torts. Let me take the definition given by John Salmon. He defines tort as a civil wrong which has unliquidated damages. Unliquidated damages, what I mean here is those damages where the amount is not fixed and it is in the form of remedy, and it can be safely concluded that it's neither a breach of contract nor a breach of trust. Another definition which is given by the Indian Limitations Act of 1963, Section 2M defines it as a civil wrong which is just not a breach of contract, neither a breach of trust. Now, torts has to be differentiated from crime. Normally, crime is a criminal offense. It's actually a violation of public law and it involves punishment which is imposed by the state. But when you come to torts, it's a civil wrong and it is strictly between the individuals, and here the victim seeks compensation in the form of damages. Whatever he has suffered, he may claim monetary damages, whereas crime is, it may result in punishment by the state. Tort has to be differentiated from contract also. The first thing is contract is codified, and as far as tort is concerned, tort is not codified. And breach of contract is actually, it's a violation of the right in personam, that is in between the parties. That means only a particular person is getting affected. But as far as tort is concerned, tort is in fact a violation of a right in rem. That means it is that a right has been vested in a particular individual and it is available against the public at large. Now, coming to the general defenses, let me start with the first let me tell you what you understand by general defenses. Actually, these defenses are applied to protect the defendant's legal rights and interest. The main purpose for providing general defenses is that a fair and just balance has to be done between the legal rights of the plaintiff and the defendant. So, these defenses actually, they provide a framework for determining whether the defendant's actions were justified under the circumstances. So you are being fair by giving the defendant a chance to defend himself. So coming to the general defenses, we have 8, the important defenses. The first one being Volenti non-fit injuria, that is the defense of consent. And the second one is when the plaintiff himself is the wrongdoer. The third defense is inevitable accident, followed by act of God, and then we have private defense, mistake, necessity, and statutory authority. We shall take each one in. We'll discuss each one in detail. To begin with, the first defense, that is Volenti non-fit injuria. It's actually a defense of consent. What it means here is the plaintiff has voluntarily assumed to suffer the harm. That means the plaintiff is aware, he has the knowledge of risk, and he has suffered the harm voluntarily. So he had a knowledge of the risk, and together he has given his consent to suffer the harm. So at this point, the defendant can pretty well argue that the plaintiff was aware of the risk involved and he has willingly accepted. So when he has voluntarily suffered the harm, then how can he claim damages from the defendant? So it's a good ground for the defendant. So basically, to this particular doctrine of voluntary non-fit injuria, it has two ingredients. The first one is that the plaintiff has the knowledge of the risk, and the second one is that the plaintiff, apart from having the knowledge of risk, he has in fact agreed to suffer the harm. Now I can give a small example. For example, if a man enters my house, I have invited a person and I cannot take action for trespassing against him because I have invited him. But if the person has entered my bedroom, then that person is guilty of trespassing. Now, in order to explain the doctrine, of voluntary non-fit injuria, I shall be dealing with two cases. The first one is R versus Williams, and the second one is Hall versus Brooklands and Racing Club. To begin with the first case, R versus Williams, in this particular case, the defendant was the teenage complainant's singing teacher. He had sex with her, telling her that his actions were a method of remedying her breathing and improving her singing. The girl agreed, believing that she was being subject to a medical or surgical intervention. And the result is the defendant was convicted for rape. The defendant appealed from his conviction on the basis that the complainant had given her consent. But the court held that this is not a case of free consent. In fact, the defendant had obtained the consent by fraud. Hence, the defendant was rightly convicted for rape. Now, coming to the second case law, Hall versus Brooklands Auto Racing Club. In this particular case, the defendant was the owner of a racing club, and the plaintiff had purchased a ticket, and he entered as a spectator. And it so happened that during the race, there was a collision between two cars, and the result was that one of the cars entered the spectators area, and the plaintiff was grievously injured. Hence, the plaintiff filed for damages against the defendant club. Now, the court held that the plaintiff knew about the risk. He had knowledge about the risk, and the fact that he has purchased the ticket is enough that he has given his consent, and therefore the court decided that the defendant is not liable to pay damages to the plaintiff. Now, another part of the doctrine of voluntary non-fit injuria is scienti non-fit injuria, which means that mere knowledge is not sufficient, that mere knowledge does not imply consent. We can prove this with the help of the case law Smith versus Baker. The plaintiff was a daily wage laborer, and he was employed to cut rock. And one of the cranes which was moving the cut rocks from one place to the other was actually hovering over the plaintiff's head. It's at that juncture that one of the rocks fell and injured the plaintiff seriously. And when the matter has gone to the court, the defendant defended himself by taking the plea of voluntary non-fit injuria. They stated that the mere contention was that the plaintiff has given knowledge, that the plaintiff was aware of the risk involved. That means he had knowledge. But mere knowledge does not imply consent. True, he had knowledge, but he has not given his consent to suffer injury. Hence, the courts decided that the defendants were liable and they had to pay damages to the plaintiff. Now, let's discuss some of the exceptions to this doctrine of voluntary non-fit injuria. We have 3 exceptions. In rescue cases, voluntary non-fit injuria will not apply. The same goes if the act is authorized. The act authorized is itself unlawful and illegal, then also the defendant cannot take the plea of voluntary non-fit injuria, and in third cases of negligence also the doctrine will not work. Now let's see discuss a case law as far as the first exception is concerned, and the case law here is Haynes versus Howard. It so happened that the defendant was the owner of 2 horses, and the defendant had left the 2 horses unattended in a street, and some mischievous children threw stones at these 2 horses, whereby the horses bolted and started running in the street. And there were some kids who were playing in the street, and the police officer entered the scene and he wanted to rescue these kids from the oncoming horses, and as a result the police officer suffered injuries, and he has filed a case against the defendant for damages. Now, the main contention of the defendant here is that the police officer knew about the risk. He was aware. The fact that he has entered and rescued means that he has given his consent. But the court applied the principle that in cases of rescue will operate as an exception to the doctrine of voluntary non-fit injuria. Now, coming to the second defense, that means plaintiff as the wrongdoer. Another defense which the defendant can take and defend himself or exempt himself from liability is the plaintiff as the wrongdoer. Now, there are a couple of Latin maxims. The first one, ex terpi causa non oritur actio. What it means is, from an immoral cause no action arises. That means, in simple words, the law excuses the defendant because the plaintiff himself is actually guilty of a wrongful act. He himself has done a wrong act. Another maxim on which this particular defense is based is jus ex injuria non oritur, which means that no right can arise out of a wrong. And there is another popular, very common phrase which we use, that one who approached the courts must come with clean hands. That means if the plaintiff, his hands are tainted, I mean he himself is guilty of an illegal act, he himself has done a wrongful act, then how can he seek justice when he himself is on the wrong path? So this is a pretty good defense for the defendant. So so let's discuss a couple of case laws. The first being Bird versus Holbrook, and the second one is Ashton versus Turner. Coming to Bird versus Holbrook, it so happened that the defendant was the owner of a garden and he used to produce flowers. And he noticed that regularly a thief is taking away his flowers. So what he does is, in order to protect his property, he sets up spring guns in his garden. Now, it so happened that the plaintiff was chasing a bird and he entered the premises of the defendant. Let us call the plaintiff as an innocent trespasser. He hasn't intentionally intruded, but as he was chasing the bird, he entered the premises. The moment he stepped on the defendant's land, the spring guns went off and he was seriously injured. Now, when the plaintiff demanded damages for his injuries, the defendant, in his content, how the defendant defendant defended himself by saying that the plaintiff himself is the wrongdoer. The plaintiff is actually guilty of trespass. So when the plaintiff himself is the trespasser, then how can he expect damages from the court? But the court refused to accept the contention of the defendant and said that the defendant has to pay damages to the plaintiff for the simple reason that the defendant did not exercise any caution or care. Had he kept a notice, be aware or something like that, then he could have escaped liability. But his failure to keep any notice made him liable, and he had to pay damages to the plaintiff. Now coming to the second case, Ashton versus Turner. In this particular case, both the plaintiff as well as the defendant had committed burglary, and they were escaping from the scene and followed by the police. The police were chasing them. It was the defendant who was driving the car, and at the time of driving the car, he was in a drunken state and he was driving very rashly and recklessly. Because of his negligence, it resulted in an accident, and the plaintiff, the co-partner in crime, suffered injuries. So the plaintiff filed a case against his fellow colleague, the defendant, demanding for damages. Here, but the claim was unsuccessful. The reason being that public policy, as a matter of public policy, the law would not recognize a duty of care owed by one participant in a crime to another. Hence, the defendant was not liable. Now coming to the third defense, that is act of God. Act of God has been defined in Black's Law Dictionary, and it says an act occasioned exclusively by violence of nature without the interference of any human agency. And it's the act of nature is such that you cannot foresee it. Now there are two essentials if the defense of act of God is pleaded. The first essential is there should be a working of natural forces. That means the nature should be in its full fury, like for example heavy rainfall, storms, tempests, volcanic eruptions. These are all acts of nature. And the second one is the occurrence must be exceptional. The human mind should not anticipate it. It should be beyond the control of humans. So in order to discuss the concept of act of God, I have taken two case laws, Nichols versus Marshland, and the second one is Ramalinga Nadar versus Narayan Redyar. Coming to Nichols versus Marshland, in this particular case, the defendant had actually created an artificial lake. That means it was an ornamental pool on his land. He had collected water from the natural streams and made an artificial lake. Once there was an extraordinary rainfall, the heaviest in the human memory. And because of the heavy rainfall, the banks of the lake gave way and the water from the lakes flooded the adjacent land, which was owned by the plaintiff. The plaintiff was the owner of 4 bridges, and because of heavy flooding, all the bridges were washed off and the plaintiff suffered serious damages to his property. When he filed a case against the defendant claiming damages, the defendant in his plea has taken the defense of act of God, and the court has taken and accepted the defense of act of God, and the plaintiff could not get any damages from the defendant. Now coming to the next case, Ramalinga Nadar versus Narayan Redyar. The defendants were actually owners of a transportation company, and the plaintiff had actually booked goods with the defendant for transportation to another state. On the way, when the defendant was carrying the plaintiff's goods, unfortunately, the goods were looted by a mob, and the prevention of which was actually beyond the control of the defendant. But one thing has to be remembered, it was held in this case that every event beyond control of the defendant cannot be said to be an act of God. And further, the court held that the destructive acts of unruly mobs cannot be considered as act of God, because human hand is at work here and the fury of nature is missing. Hence, the court held that the defendant is liable and he has to pay damages to the plaintiff for the loss of goods. Now, coming to the next defense, that is inevitable accident. Inevitable accident means it is one which could not have possibly been avoided by the exercise of due care and caution. You have exercised due care and caution. In spite of that, if it has resulted in an accident that you do not have control over the events, then the defendant, and that is inevitable accident for you. So, in order to explain the concept, let's discuss a couple of cases. The first one being Brown versus Kendall. In this particular case, both the plaintiff as well as the defendant were owners of dogs, and one fine day both the dogs were fighting among themselves, and both the defendant as well as the plaintiff were present at the scene. The defendant took a stick and it was trying to separate the dogs who were fighting among themselves. The plaintiff was just a bystander, a spectator who is watching all this. Now, it so happened that the defendant, he took the stick and he swung his arm to separate the dogs, but unfortunately, the plaintiff was just standing behind the defendant and the stick poked his eye, and it was a permanent eye injury to him. And the plaintiff has filed for damages for the loss of his eyesight. Now, the court decided that it was indeed an inevitable accident, and the defendant, the plaintiff, is without any remedy because the defendant has not done it intentionally. It was just an accident. Coming to the second case, Stanley versus Powell. In this particular case, there was an hunting expedition, and the plaintiff's services were taken so that he could carry the cartridges and the other luggage of this hunting expedition. It so happened that the defendant, he saw a pheasant passing and he takes aim at the pheasant, but the pellet from the gun, instead of hitting the bird, it hits the tree, backfires and hits the plaintiff who is standing nearby. And the result is he lost his eyesight, and when he demanded damages from the defendant held that it is an inevitable accident, and the court also has decided that it is inevitable accident because the defendant has not done it intentionally. There wasn't any revenge or anything. It was just an accident. Hence, the plaintiff could not get any damages. Now, coming to the third case, Farden versus Harcourt. In this particular case, a couple goes to the market for shopping and they leave the dog behind. In fact, they lock the dog in the car. The dog gets restless. Actually, normally the dog is a very good one, it's a docile dog, not a mischievous dog as such. Now, the dog gets restless and it starts jumping on the seat. It is at that juncture that the plaintiff is passing the car, and when the dog is agitated and it's jumping, it jumps on the window and the splinters of glass flew from there and hit the plaintiff in his eye, and he also suffered serious injuries. When he filed a case against the defendant for damages, the defendant in his defense has taken inevitable accident, and the court has accepted the defense of inevitable accident because it was not an intentional tort, and whatever happened, it was an inevitable accident. Hence, the defendants were not liable in this case. Now, coming to the fourth defense, the private defense, every individual has a right to protect his life and his property, and in doing so, he can use a certain amount of force if necessary. But there are conditions when you use the private defense. The first condition being that the defendant should feel that there is a real and imminent threat to himself, that his life is in danger, his property is in danger. When there is an immediate threat, then only he can use the force. So, the case here is Morris versus Nugent. In this particular case, the defendant was actually passing by the plaintiff's house, and the plaintiff's dog bit the defendant. The defendant was furious. He raised his gun in order to shoot the dog in his private defense. But at this point, the dog simply turned and ran away. In spite of that, the defendant shot the dog and killed it. So the plaintiff has filed for damages for his dog. Now, the defendant has taken the plea of private defense. He says that in order to defend himself, he has used force and killed the dog. But the court has not accepted his plea because the defendant, there wasn't any real and imminent threat to the defendant. The fact that the dog turned away and walked away means that the defendant is out of danger. But the defendant probably was furious because the dog had bitten him. So whatever he has done is, he was being revengeful by killing the dog. Hence, the court has not accepted the plea of the defendant. The second condition for this defense is that force should be used only for the purpose of protection or for defense and not for revenge. You are using private defense only for protecting yourself, that is protecting your life and property, but no way it can be used for revenge. As we have seen in the last case, the defendant was annoyed with the fact that the dog had bitten him. So he shot him, and that was out of revenge and not protection. Okay, coming to the third condition, the force used by the defendant should be in proportion to the act committed. Whatever force you have used, it should be in proportion to the act. It should not be beyond that. For example, if a person has committed theft, you cannot hang him. Coming to the next, defense of necessity. Now, another defense of which the defendant can claim is the defense of necessity. There is a very popular saying, necessity needs no law. Yes, it is based on a popular principle, salus populi suprema lex. That means the welfare of the people is a supreme law. So, you can defend yourself if there is a dire need. I mean, it is necessity as a defense by the defendant. Necessity as a defense in murder is not acceptable, but necessity as a defense can be accepted in the tort. Apart from these defenses, we have other defenses also, mistake and statutory authority. These defenses I shall be taking in the next session. Thank you for now.